Chapter 1. Introduction to Fundamental Rights, Meaning of State and Law. Articles 12 to 13. A fundamental right is one which is protected and guaranteed by the written constitution of the state. These are called fundamental because ordinary rights may be altered by the legislature in its ordinary process of legislation, but fundamental right being guaranteed by the constitution cannot be altered by any process shorter than required for amending the constitution itself. Nor can it be suspended or abridged except in the manner laid down in the Constitution itself. Further, they are most essential for the attainment of full intellectual, moral and spiritual status. The negation of these rights will keep the moral and spiritual life of an individual stunted and his potentialities underdeveloped. Fundamental rights were deemed essential to protect the rights and liberties of the people against the encroachment of the power delegated by them to their government. Thus, the fundamental rights being guaranteed by the fundamental law of the land, no organ of the state, i.e. executive, legislative or judicial, can act in contravention of such rights, and any such act which is repugnant to such rights will be void to the extent of repugnancy. In A.K. Gopalan vs. State of Madras, Air 1950 SC 27, Patanjali Sastri CJ, observed as follows. The insertion of fundamental rights in the forefront of a constitution coupled with an express prohibition against legislative interference with these rights and the provision of constitutional sanction for the encroachment of such prohibition by means of judicial review is a clear and emphatic 1. D. D. Basu, Commentary on the Constitution of India, Vol. I. ed. V. pp. 126 to 127. 2. Hurtado vs. People of California, 28 led 232 as per Justice Matthews. Indication that these rights are to be paramount to ordinary state-made laws. In Menka Gandhi vs. Union of India, 1978, 1 S.C. C. 248, Bhagwati J. observed as follows. Fundamental rights represent the basic values cherished by the people of this country since the Vedic times, and they are calculated to protect the dignity of the individual and create conditions in which every human being can develop his personality to the fullest extent. They weave a pattern of guarantee on the basic structure of human rights, and impose negative obligations on the state not to encroach on individual liberty in its various dimensions. Fundamental rights are regarded as fundamental because they are the most essential for the attainment by the individual of his full intellectual, moral and spiritual status. These fundamental rights help not only in protection but also the prevention of gross violation of human rights. In M. Nagraj vs. Union of India, 2006-8 S.C. C. 212, the Supreme Court observed as follows. Fundamental rights are not gift from state to its citizens. Individuals possess basic human rights independently of any constitution by reason of basic fact that they are members of the human race. These fundamental rights are important as they possess intrinsic value. Part 3 of the Constitution does not confer fundamental rights. It confers their existence and gives them protection. Its purpose is to withdraw certain subjects from the area of political controversy and to place them beyond the reach of majorities and officials and to establish them as legal principles to be applied by the courts. Every right has a content. Every foundational value put in Part 3 as fundamental right has intrinsic value. The converse does not apply. A right becomes a fundamental right because it has fundamental value. The object behind the inclusion of fundamental rights in the Constitution is to establish a government of law and not of man, i.e. a governmental system where the tyranny of majority does not oppress the minority. In short, the object is to establish rule of law. Origin and development of fundamental rights. The origin of the concept of fundamental rights may be traced back to the 13th century England, where the people of England revolted against King John and demanded respect for their liberties and end of royal absolutism. The king agreed not to detain persons without trial, which resulted in drafting of Magna Carta in 1215. It enjoined respect for the law by the king, forbade denial of or delayed justice, prohibited unlawful detention and excessive fines. After this, in 1628, a petition of rights was presented to King Charles I, which required transfer of sovereignty from king to parliament. Parliament debated on this and finally it was passed as Bill of Rights 1689 by British Parliament. It dealt with the rights and liberties of the British citizen. Further, France enacted Declaration of Rights of Man and Citizen in 1789, which declared the natural, inalienable and sacred rights of man. Following the spirit of the Magna Carta of the British and the Declaration of the Rights of Man and Citizen of France, the Americans incorporated the Bill of Rights in their constitution in 1791 in the form of first 10 amendments to the Constitution. Ever since the incorporation of Bill of Rights in the U.S. Constitution in 1791, it has become a tradition to incorporate the provisions of fundamental rights in the Constitution of democratic countries. In India, perhaps the first explicit demand for fundamental rights appeared in the Constitution of India Bill, 1895, also known as Swaraj Bill of 1895, which specified certain constitutionally guaranteed rights to citizens, inter alia, freedom of expression, inviolability of one's house, and equality before the law. The Commonwealth of India Bill or Indian Home Rule Bill, 1924, envisaged a statement of rights almost identical in scope and nature with those adopted by the Irish Constitution of 1921. The Indian National Congress passed a resolution in 1927 in Madras, which declared, the basis of the future Constitution of India must be a declaration of fundamental rights. Thereafter the Nehru Committee Report, 1928, exhaustively treated the issue of fundamental rights. The Congress adopted a resolution again in its Karachi session in March 1931 on fundamental rights and economic and social changes. Ultimately, Sections 275 and 297 to 300 of the Government of India Act, 1935 conferred certain rights on British subjects in India. This included the right against discrimination in respect of employment and the right to property, as also other rights protecting grants of land free of revenue or subject to remissions of land revenue etc. 4. Constitutional Law 2. Liberties is particularly great in parliamentary system as those who form the government enjoy a majority support in the legislature and can get laws made according to their wishes. Finally, when Constitution came into force on the 26th of January 1950, Part 3 of the Constitution containing Article 12 to 35 contained the provisions relating to fundamental rights which constitutes the Magna Carta of Indian democracy. The whole object of Part 3 of the Constitution is to provide protection for the freedoms and rights mentioned therein against arbitrary invasion by the state. Nature and scope of fundamental rights. The fundamental rights guaranteed in the Constitution of India are characterized by certain features which are as follows. 1. The fundamental rights are universal, i.e., they are applicable to all citizens of India irrespective of caste, color, creed, sex and religion. For example, Articles 15, 16, 19, 29 and Article 30 are the fundamental rights which are exclusive to the citizens of India, and Articles 14, 20, 21, 21A, 23, 24 and 25 to 28 are the fundamental rights which are applicable to any person living in India except to the enemy aliens. 2. The fundamental rights are individual rights and are enforceable against the state and not against individuals except right against untouchability, Article 17, right against exploitation, Articles 23 and 24, and right to personal liberty, Article 21, where an individual can be taken to the court of law in case of violation. In I.R. Coelho vs. State of Tamil Nadu, A. 2007, South Carolina 861, a 9-judge bench of the Supreme Court observed that fundamental rights are not limited narrow rights, but rights which provide a broad check against the violations and excesses by the state authorities. These rights have proved to be the most significant constitutional control on the government, particularly legislative power. They form a comprehensive test against the arbitrary exercise of state power in any area. In People's Union for Democratic Rights vs. Union of India, A. 1982 SC 1473, the Supreme Court held that whenever a fundamental right contained in Articles 17, 23 or 24 is being violated by a private individual, it would be a constitutional obligation of the state to take necessary steps to interdict such violation and ensure that such person should respect that right. Merely because the aggrieved person could himself protect or enforce his invaded fundamental right, do not absolve the state from its constitutional obligation. In 1946, when Constituent Assembly was formed to draft the Constitution of India, a subcommittee on fundamental rights was also formed. The committee being influenced by the Bill of Rights of the American Constitution, the Declaration of the Rights of Man in France, the Irish Constitution of 1935, the post-war Constitution of Japan and Burma and the Declaration of Human Rights by the United Nations included the provision of fundamental rights in Part 3 of the Indian Constitution as they thought that danger of encroachment on citizens. Introduction to Fundamental Rights, Meaning of State and Law. 5. 3. Fundamental rights has both negative and positive aspects. Some fundamental rights impose restrictions on the actions of state, i.e. they mandate state not to do a particular type of act, like Article 14, which embodies that the state shall not deny to any person equality before the law. Similarly, Articles 15, 1, 16, 2, 18, 1, 20, 21, 22, 1, and 28, 1, are some other fundamental rights which impose restrictions on the state. Therefore, they can be said to constitute negative rights. On the other hand, some fundamental rights directly confer rights upon the citizens of India, without even containing any provision relating to the actions of the state, like Article 19, 1, which embodies that all citizens shall have the right, a. to freedom of speech and expression, b. to assemble peaceably and without arms, etc. Similarly, Article 21A, 25, 1, 29, 1, and 30, 1, are some fundamental rights which directly confer rights on the citizens. 4. Most of the fundamental rights are self-executory and does not require any legislation to enforce them, but there are certain fundamental rights which require further legislation to make them enforceable. For e.g. Article 17, Abolition of Untouchability, Parliament enacted Untouchability Offences Act, 1955, which was renamed as Protection of Civil Rights Act, 1955, and Scheduled Castes and Scheduled Tribes, Prevention of Atrocities Act, 1989 for enforcing Article 17. Article 21A, Right to Education, Parliament enacted the Right of Children to Free and Compulsory Eviction Act, 2009 for enforcing Article 21A. Article 23, Prohibition of Traffic in Human Beings and Forced Labor, Parliament enacted Suppression of Immoral Traffic in Women and Girls Act, 1956, which was later renamed as the Immoral Traffic Prevention Act, 1956 for enforcing Article 23. Article 24, Prohibition of Employment of Children in Factories, etc. Parliament enacted the Child Labour Prohibition and Regulation Act, 1986, the Employment of Children Act, 1938, the Children Pleading of Labour Act, 1933, the Indian Factories Act, 1948, the Mines Act, 1952, the Merchant Shipping Act, 1958, the Motor Transport Workers Act, 1951, the Plantation Labor Act, 1951, the Bidi and Cigar Workers, Conditions of Employment, Act, 1966, the Apprentices Act, 1961 etc. For enforcing Article 24. 5. The provision of Article 14, 15, except Article 15, 2, 16, 18 and 29, 2, embody the equality principles. On the other hand, Articles 19, 20, 21, 22, 25. 6. Constitutional Law 2. 26, 27 and 28 embody the liberty principles. While Articles 15, 2, 17, 214, 23, 24, 29 and 30 embody the principles of equality as well as liberty. 6. Every fundamental rights provided under Constitution are not absolute and Constitution imposes certain limitations on its exercise. For example, Article 19 guarantees to all citizens freedom of speech and expression, but citizens are required not to utter anything which may affect foreign relations. Similarly, Article 16 provides for equality of opportunity for all citizens, but the state has been empowered to make reservation in appointment in favor of scheduled castes and scheduled tribes. However, some of the fundamental rights are absolute. These rights are right against untouchability, Article 17, right against engaging children below 14 years of age in hazardous units, Article 24, and right to freedom of conscience, Article 25, 1. Classification of fundamental rights. The Indian Constitution guarantees 6 types of fundamental rights. 1. Right to equality, Articles 14 to 18. Article 14. Equality before law and equal protection of law. Article 15. Prohibition of discrimination on the basis of caste, creed, sex, religion and place of birth. Article 16. Equality of opportunity in public employment. Article 17. Abolition of untouchability. Article 18. Abolition of titles. 2. Right to freedom, Articles 19 to 22. Article 19. A. Freedom of speech and expression. B. Assembly. C. Association. D. Movement. E. Residence. G. Choose profession. Note: Clause F has been deleted through 44th Amendment. Article 20. Protection in respect of conviction for offences. Article 21. Protection of life and personal liberty. Article 21A. Right to education. Article 22. Protection against arrest and detention in certain cases. Article 23. 3. Right against exploitation, Articles 23 and 24. Prohibition of traffic in human beings and forced labor. Article 24. Prohibition of employment of children below 14 years of age in factories and hazardous employment. Introduction to fundamental rights, meaning of state and law. 4. Right to freedom of religion, Articles 25 to 28. Article 25, Freedom of religion in India. Article 26, Freedom to manage religious affairs. Article 27, Freedom from taxes for promotion of any particular religion. Article 28, Freedom as to attendance at religious instruction in certain educational institutions. 5. Right to culture and educational minorities, Articles 29 and 30. Article 29, Protection of language, script or culture of minorities. Article 30. Right of minorities to establish and manage educational institutions. 6. Right to constitutional remedies, Article 32. Article 32. Remedies for enforcement of the fundamental rights through the issue of certain writs by Supreme Court. 1. Habeas corpus. 2. Mandamus. 3. Prohibition. 4. Quo warranto. 5. Certiorari. Note: in the original constitution there were 7 types of fundamental rights, but the right to property was taken away from the list of fundamental rights by the 44th Constitutional Amendment Act, 1978 and put in the category of civil rights, under Article 300A, meaning thereby that if violated, one cannot directly go to high courts or Supreme Court for their enforcement. Limitations on the fundamental rights. The group of Articles 31A, 31B, 31C, 33, 34 and 35 lays down various limitations on the fundamental rights and the circumstances under which these limitations may be imposed. Article 31A was intended to enable the state to achieve the abolition of zamindari and other similar tenures. Article 31B validated the acts and regulations mentioned in the 9th schedule. The intention of Article 31C was to save laws giving effect to directive principles of state policy specified in Articles 39B and C. Suspension or denial of fundamental rights. The rights contained in Part 3 can be curtailed or suspended in the following cases. A. Under Article 33, Parliament may, by law, restrict or abrogate any of the fundamental rights in their application to the members of the armed forces or forces charged with maintenance of public order or other analogous forces. B. Article 34 authorizes Parliament to make law to grant immunity in respect of acts done by any person during the operation of martial law in the country. Constitutional Law 2. C. Article 358 provides that when the proclamation of emergency is made by the President under Article 352, the freedom guaranteed by Article 19 are automatically suspended for the period of emergency. Article 359 further empowers the President to suspend the right to move any court for the enforcement of fundamental rights, except Article 20 and 21, during the continuance of emergency. Concept of state under Article 120.1.2. Q. 3. Article 12, Definition of state. Article 12 is an interpretative article and lays down that in Part 3 of the Constitution, unless the context otherwise requires, the term state includes the following: executive and legislature of union and states. All local or other authorities within the territory of India or under the control of Government of India. A perusal of the above article shows that the definition of state is inclusive and provides that state includes the following. 1. The Government and Parliament of India, i.e., Executive and Legislature of the Union. 2. The Government and the Legislature of each state, i.e., Executive and Legislature of states. 3. All local or other authorities within the territory of India, or under the control of the Government of India. 1. Government and Parliament of India. The term state includes Government of India, i.e. Union Executive, and the Parliament of India, i.e. Union Legislature. The term government stands to include a department of government or any institution under the control of a department of government, e.g. the Income Tax Department or the Forest. Q. 1. Why was Article 12 inserted in the chapter of fundamental rights? Explain the expanded meaning of term other authorities with the help of decided cases which widen the area of definition of state in a welfare state. Is judiciary included in the word state? Du. Ul. B. 2019. Q. 2. Discuss citing case law. When can the following bodies be considered as state for the purpose of enforcement of India? A. Government company established under Companies Registration Act, 1956. B. Statutory corporation set up by a statute. C. Society set up by the government and registered under the Societies Registration Act, 1860. Du. Ul. B. 2015. Q. 3. Article 12 winds up the list of authorities falling within the definition of state by referring to other authorities within the territory of India or under the control of the Government of India. What are these other authorities? Explain with the help of judicial pronouncements. D.U. Ul. B. 2013. Introduction to Fundamental Rights, Meaning of State and Law. 9. Research Institute, Dehradun. The President, while acting in his official capacity, must be included in the term government and be regarded as the state for the purposes of Part 3. 2. Government and legislature of each state. The term state includes government of each state, i.e. state executive, and legislature of each state, i.e. state legislature. It includes union territories as well. 3. Local or other authorities within the territory of India. The expression local authorities is defined in Section 3(31) of the General Clause Act, 1897 as follows: local authority shall mean a municipal committee, district board, body of port commissioners or other authority legally entitled to or entrusted by the government with the control or management of a municipal or local fund. The expression other authorities has neither been defined in the Constitution nor in any statute. Therefore, to understand the expanded meaning of the term other authorities in Article 12, it is necessary to trace the origin and scope of Article 12 in the Indian Constitution. Article 12 was introduced in the draft Constitution as Article 7. While initiating a debate on this article in the draft Constitution in the Constituent Assembly, Dr. Ambedkar described the scope of this article and the reasons why this article was placed in the chapter on fundamental rights as follows. The object of the fundamental rights is twofold. First, that every citizen must be in a position to claim those rights. Secondly, they must be binding upon every authority. The word authority means a body which has got either the power to make laws or the power to have discretion vested in it. Therefore, it is quite clear that if the fundamental rights are to be clear, then they must be binding not only upon the central government or the provincial government, or upon the governments established in the Indian states, but they must also be binding upon district local boards, municipalities, even village panchayats and taluk boards, in fact every authority which has been created by law and which has got certain power to make laws, to make rules, or to make bylaws. Cubed. From the above, it is clear that the intention of the Constitution framers in incorporating this article was to treat any authority which has been created by law and which has got certain powers to make laws, to make rules and regulations to be included in the term other authorities, as found presently in Article 12. 10. Constitutional Law 2. Judicial Opinion on Other Authorities, Q. 4. For the first time the expression other authorities was interpreted by the Madras High Court in University of Madras vs. Shanta Bai, Air 1954 Mat 67, where it was held that the words local or other authorities must be construed aegisdum generis with the government or legislature, and so construed can only mean authorities exercising governmental functions. But this view of Madras High Court was not accepted by Supreme Court. In Ujjam Bai vs. State of UP, Air 1962 South Carolina 162, the Apex Court held that the rule of aegisdum generis could not be applied in interpreting the expression other authorities occurring in Article 12 of the Constitution. The court held that there is no common genus running through these named bodies, nor these bodies can be placed in one single category on any rational basis. In Rajasthan State Electricity Board vs. Mohanlal, Air 1967 South Carolina 1857, a constitution bench of Apex Court held that the expression other authorities is wide enough to include within it every authority created by a statute on which powers are conferred to carry out governmental or quasi-governmental functions and functioning within the territory of India or under the control of the Government of India, emphasis supplied. Even while holding so, Shah, J. in a separate but concurring judgment observed that every constitutional or statutory authority on whom powers are conferred by law is not other authority, within the meaning of Article 12. He also observed further that it is only those authorities which are invested with sovereign powers, that is, power to make rules or regulations and to administer or enforce them to the detriment of citizens and others, that fall within the definition of state in Article 12. But constitutional or statutory bodies invested with power but not sharing the sovereign power of the state are not state within the meaning of that article. After a decade, another constitution bench of Apex Court somewhat expanded this concept of other authorities. In Sukhdev Singh vs. Bhagatram Sardar Singh Raghuvanshi, Air 1975 South Carolina 1331, 1975, 1 S.C. C. 421, the question was whether the oil in Q. 4. The judicial expansion of the term other authorities came about primarily with a view to prevent government from bypassing its constitutional obligations by creating companies, corporations etc. to perform its duty. Explain the meaning of the term state under Article 12 in light of the above statement. D.U. Al. B. 2014. Q. 5. A statutory corporation, X, with 100% of its shares held by the Government of India, is engaged in the refining and sale of petrol and petroleum products. The government sells 51% of its holdings in the company as part of the policy of disinvestment. Introduction to Fundamental Rights, Meaning of State and Law. 11. Natural Gas Commission, the Industrial Finance Corporation and the Life Insurance Corporation, each of which are public corporations set up by statutes or authorities within the meaning of Article 12. The case was decided by a majority of 4:1. A. N. Ray, C.J. speaking for himself and on behalf of Y.V. Chandrachud and A.C. Gupta, J.J. held that all the three statutory corporations were given birth by statutes. The circumstance that these statutory bodies were required to carry on some activities of the nature of trade or commerce did not make any difference. The Life Insurance Corporation is I, an agency of the government, E, carrying on the exclusive business of life insurance, i.e. in monopoly, and E, each and every provision of the statute creating it showed that the corporation is the voice in the hands of the central government. The Industrial Finance Corporation is in effect managed and controlled by the central government, citizens cannot be its shareholder. ONGC, I, is owned by the government, E, is a statutory body and not a company, and E, has the exclusive privilege of extracting petroleum. Each of the three, respectively under the three acts under which they are created, enjoy power to do certain acts and to issue directions the breach of which is punishable as an offense. These distinguish them from a mere company incorporated under the Indian Companies Act. The common features of the three were, I, rules and regulations framed by them have the force of law, E, the employees have a statutory status, and E, they are entitled to declaration of being in employment when the dismissal or removal is in contravention of statutory provisions. The Chief Justice further held that, however, these provisions did not make the employees as servants of the Union or the state, though the three statutory bodies are authorities within the meaning of Article 12 of the Constitution. Matthew, J. in his concurring judgment further observed that there is need to expand the definition of the term, other authorities, in the following words. The concept of state has undergone drastic changes in recent years. Today, state cannot be conceived of simply as a coercive machinery wielding the thunderbolt of authority. It has to be viewed mainly as a service. A society, Y, registered under State-Level Societies Registration Act is the governing body for cricket in that particular state. The employees of corporation, X, as well as society, Y, have been terminated, and seek your advice on whether these employees can file writ petitions challenging their termination or not. Advise them on whether such writ petitions will lie under Article 12 or Article 226. Give separate answers of your advice to employees of corporation X and society Y, citing case law. Du. Al. B. 2016. 12. Constitutional Law 2. Corporation. A state is an abstract entity. It can only act through the instrumentality or agency or natural or juridical persons. There is nothing strange in the notion of the state acting through a corporation and making it an agency or instrumentality of the state. With the advent of a welfare state, the framework of civil service administration became increasingly insufficient for handling the new tasks, which were often of a specialized and highly technical character. The distrust of government by civil service was a powerful factor in the development of a policy of public administration through separate corporations which would operate largely according to business principles and be separately accountable. The public corporation, therefore, became a third arm of the government. The employees of public corporation are not civil servants. Insofar as public corporations fulfill public tasks on behalf of government, they are public authorities and as such subject to control by government. The public corporation, being a creation of the state, is subject to the constitutional limitation as the state itself. The governing power wherever located must be subject to the fundamental constitutional limitations. He then propounded 4 indicia for identifying an agency or instrumentality. 1. A finding of the state financial support plus an unusual degree of control over the management and policies might lead one to characterize an operation as state action. 2. Another factor which might be considered is whether the operation is an important public function. 3. The combination of state aid and the furnishing of an important public service may result in a conclusion that the operation should be classified as a state agency. If a given function is of such public importance and so closely related to governmental functions as to be classified as a governmental agency, then even the presence or absence of state financial aid might be irrelevant in making a finding of state action. If the function does not fall within such a description, then mere addition of state money would not influence the conclusion. 4. The ultimate question which is relevant for our purpose is whether such a corporation is an agency or instrumentality of the government for carrying on a business for the benefit of the public. In other words, the question was, for whose benefit was the corporation carrying on the business? From the above, it is to be noticed that because of the change in the socio-economic policies of the government, this court considered it necessary by judicial interpretation to give a wider meaning to the term other authorities in Article 12 so as to include such bodies which were created by act of legislature to be included in the term other authorities. This judicial expansion of the term other authorities came about primarily with a view to prevent the government from bypassing its constitutional obligations by creating companies, corporations etc. to perform its duties. At this stage it is necessary to refer to the judgment of Subhajit Tewari vs. UOI and Oz. Air 1975 South Carolina 1339, which was delivered by the very same Constitution Bench which delivered the judgment in Sukhdev Singh and Oz. Supra, on the very same day. In this judgment, this court, noticing its judgment in Sukhdev Singh and Oz. Supra, rejected the contention of the petitioner therein that Council for Scientific and Industrial Research, which was registered under the Societies Registration Act, would come under the term other authorities in Article 12. The court dismissed the petition on the ground that the Council for Scientific and Industrial Research does not have a statutory character like the Oil and Natural Gas Commission, or the Life Insurance Corporation or Industrial Finance Corporation. It is just a society incorporated in accordance with the provisions of the Societies Registration Act. The distinction between the two judgments referred to herein above, namely Sukhdev Singh and Subhajit Tewari, is that in the former the court held that bodies which were creatures of statutes having important state functions and where the state had pervasive control of activities of those bodies would be state for the purpose of Article 12. While in Subhajit Tewari case, the court held that a body which was registered under a statute and not performing important state functions and not functioning under the pervasive control of the government would not be a state for the purpose of Article 12. Subsequent to the above judgments of the Constitution Bench, a three-judge bench of Supreme Court in the case of Ramana Dyaram Shetty vs. the International Airport Authority of India and Oz. Air 1979 South Carolina 1628, consisting of Justice P. N. Bhagwati, V. D. Tuljapurkar and R. S. Pathak, placing reliance on the judgment of this court in Sukhdev Singh and Oz. Supra, held that the International Airport Authority, which was an authority created by the International Airport Authority Act, 1971, was an instrumentality of the state, hence, came within the term, other authorities, in Article 12, while doing so court observed as follows. Today the government, in a welfare state, is the regulator and dispenser of special services and provider of a large number of benefits. The valuables dispensed by government take many forms, but they all share one characteristic. They are steadily taking the place of traditional forms of wealth. These valuables which derive from relationships to government are of many kinds: leases, licenses, contracts and so forth. With the increasing magnitude and range of governmental functions as we move closer to a welfare state, more and more of our wealth consists of these new forms. Some of these forms of wealth may be in the nature of legal rights, but the large majority of them are in the nature of privileges. But on that account it cannot be said that they do not enjoy any legal protection, nor can they be regarded as that they do not enjoy any legal protection, nor can they be regarded as gratuity furnished by the state so that the state may withhold, grant or revoke it at its pleasure. The law has not been slow to recognize the importance of this new kind of wealth and the need to protect individual interest in it, and with that end in view, it has developed new forms of protection. Some interest in government largesse, formerly regarded as privileges, have been recognized as rights, while others have been given legal protection not only by forging procedural safeguards but also by confining, structuring and checking government discretion in the matter of grant of such largesse. The discretion of the government has been held to be not unlimited, in that the government cannot give or withhold largesse in its arbitrary discretion or at its sweet will. It is in the above context that the bench in Ramana Dyaram Shetty's case laid down the parameters or the guidelines for identifying a body as coming within the definition of other authorities in Article 12. They are as follows. 1. One thing is clear, that if the entire share capital of the corporation is held by government, it would go a long way towards indicating that the corporation is an instrumentality or agency of government. 2. Where the financial assistance of the state is so much as to meet almost entire expenditure of the corporation, it would afford some indication of the corporation being impregnated with governmental character. 3. It may also be a relevant factor whether the corporation enjoys monopoly status, which is state conferred or state protected. 4. Existence of deep and pervasive state control may afford an indication that the corporation is a state agency or instrumentality. 5. If the functions of the corporation are of public importance and closely related to governmental functions, it would be a relevant factor in classifying the corporation as an instrumentality or agency of government. 6. Specifically, if a department of government is transferred to a corporation, it would be a strong factor supportive of this inference, of the corporation being an instrumentality or agency of government. It is interesting to note that on the same day, another three-judge bench of Supreme Court consisting of V. R. Krishnaiah, O. Chinnappa Reddy and R. S. Pathak, J.J. delivered judgment in Som Prakash Rekhi vs. Union of India Air 1981 South Carolina 212, where the court expanded the meaning of other authorities. Supreme Court held that these tests are not exhaustive because it is not possible to make an exhaustive enumeration of the tests which would apply in all cases to find an answer that whether it is a corporation of government's instrumentality or the agency. Leading case: Som Prakash Rekhi vs. Union of India. Air 1981 South Carolina 212. Facts. The petitioner was Clark in Burma Shell Company Limited, which was later taken over by the central government. Under a statute, all its assets and liabilities devolved upon its successor Bharat Petroleum. The petitioner sought retirement on reaching the age of 50 years and after qualifying for pensionary and other benefits under the rules framed by the company. On his retirement, he received his gratuity and pension of Rs. 165.90 plus PF, which was non-contributory one. He was also paid discretionary pension of Rs. 86 PM for 13 months, which was later stopped because the petitioner resorted to litigation as agreed by him. Later, under a notification, the corporation reduced his pension on the ground that since he had received his PF and gratuity, so his pension should be reduced, pro tanto. His pension was reduced to Rs. 40.05. The petitioner filed a writ that his right to property has been infringed. Issue: whether Bharat Petroleum Corporation Limited, a statutory corporation, was an authority, and therefore, the state, under Article 12. Decision: a three-judge bench consisting of Justices V.R. Krishnaiah, O. Chinnappa Reddy and R.S. Pathak held that a government company, registered as a company under the Indian Companies Act, Bharat Petroleum is a state, within the enlarged meaning of Article 12. The expression, other authorities, is not confined only to statutory corporations alone but also a non-statutory body like government company, a registered society, or bodies which have some nexus with the government. The emphasis is on functionality plus state control rather than on the statutory character of the corporation. There is no reason to make exclusions on sophisticated grounds such as that the legal person must be statutory corporation, must have power to make law, must be created by and not under a statute, i.e. a corporation created by a statute versus a company or society created under the statute, e.g. FCI created by Food Corporation Act, 1964. A company registered under the Indian Companies Act. Certain observations made by Krishnaiah, J. are pertinent. Any authority under the control of the Government of India comes within the definition. While dealing with the corporate personality, it has to be remembered that, while the formal ownership is cast in the corporate mold, the reality reaches down to state control. The core fact is that the central government chooses to make over, for better management, its own property to its own offspring. A government company is a mini incarnation of the government itself, made up of its blood and bones and given corporate shape and status for defined objectives and not beyond. The device is too obvious for deception. A government company, though, is but the alter ego of the central government, and tearing of the juristic veil worn would bring out the true character of the entity being the state. Krishnaiah, J. held it to be immaterial whether the corporation is formed by a statute or under a statute. The true test is functional. Not how the legal person is born but why it is created. He further held that both the things are essential, i.e., discharging functions or doing business as the proxy of the state by wearing the corporate mask, and e. an element of ability to affect legal relations by virtue of power vested in it by law. These tests, if answered in positive, would entail the corporation being an instrumentality or agency of the state. What is an authority? Krishnaiah, J. defined authority as one which in law belongs to the province of power, and the search here must be to see whether the act vests authority, as agent or instrumentality of the state, to affect the legal relations of oneself or others. He quoted the definition of authority from the law lexicon by P. Ramanatha Iyer to say, authority is a body having jurisdiction in certain matters of a public nature, and from Salmon's jurisprudence, to say that the ability conferred upon a person by the law to alter, by his own will directed to that end, the rights, duties, liabilities or other legal relations, either of himself or of other persons, must be present to make a person an authority. He held BPL to be a limb of government, an agency of the state, a vicarious creature of statute, because of these characteristics, which he found from the provisions of the Act which created it and other circumstances viz. I. It is not a mere company but much more than that. E. It has a statutory flavor in its operations and functions, in its powers and duties and in its personality itself. E. It is functionally and administratively under the thumb of the government. And IV. The company had stepped into the shoes of the executive power of the state and had unique protection, immunity and powers. In conclusion, Krishna Laya, J. held that the case of Bharat Petroleum Limited, BPL, was a close parallel to Airport Authority case, Ramana Dayaram Shetty vs. International Airport Authority of India, Air 1979 South Carolina 1628, accepting that the Airport Authority is created by a statute while Bharat Petroleum Limited, BPL, is recognized by and clothed with rights and duties by the statute. Krishna Laya, J. having culled out the several tests from Ramana case, Ramana Dayaram Shetty vs. International Airport Authority of India, 1979, 3 SC 489, Air 1979 South Carolina 1628, and added a clinching footnote: the finale is reached when the cumulative effect of all the relevant factors above set out is assessed, and once the body is found to be an instrumentality or agency of the government, the further conclusion emerges that it is the state and is subject to the same constitutional limitations as the government, and it is this divagation which explains the ratio of Ramana case, Ramana Dayaram Shetty vs. International Airport Authority of India, 1979, 3 SC 489, Air 1979 South Carolina 1628. Status of non-statutory body like registered society Q. 5. Q. Ajay Hansia vs. Khalid Mujib Sehirawadi, Air 1981 South Carolina 487. Facts. The case involved a society registered under the Jammu and Kashmir Registration of Societies Act, running the Regional Engineering College at Srinagar, sponsored by the Government of India. Admissions to the college are made by a committee after taking into account the marks obtained in the entrance test for 100 marks and a viva voce for 50 marks, which was distributed as follows: I. General knowledge and awareness 15 marks. E. Broad understanding of specific phenomenon 15 marks. E. Extracurricular activities 10 marks. And IV. General personality trait 10 marks. The petitioners applied for admission to the college and appeared for the written test and viva voce, where the interview of each of them did not last for more than 2 or 3 minutes per candidate on an average, and the only Q. 6. Discuss whether a society registered under the Societies Registration Act is a state within the meaning of Art. 12 of the Constitution. Du. Ul. B. 2011. Q. 7. This contrivance of carrying on business activities by the state through statutory corporations, government companies and other bodies with legal personality, simplification and facilitates transactions and operations beyond the traditional and tardy processes of governmental. But to use the corporate methodology is not to liberate the state from its basic obligation to obey Part 3. Otherwise, a cunning plurality of corporations taking over almost every state business will cheat the people of Part 3 rights by the easy plea: no admission for the Bill of Rights. No state here. The nation will be told that the state has ceased to be, save for the non-negotiable sovereign functions. And fundamental rights may suffer eclipse only to be viewed in museum glass cases. Such a situation will be a treachery. Critically examine the statement on the basis that Article 12 is a special definition with a broader goal, in the light of new socio-economic realities of 21st. The nation will be told that the state has ceased to be, save for the non-negotiable sovereign functions. And fundamental rights may suffer eclipse only to be viewed in museum glass cases. Such a situation will be a treachery on the founding fathers. Critically examine the statement on the basis that Article 12 is a special definition with a broader goal, in the light of new socio-economic realities of 21st century India. D.U. Ul. B. 2017. Questions which were asked to them were formal questions relating to their parentage and residence, and hardly any question was asked which would be relevant to any of the 4 factors for which marks were allocated at the viva voce examination. When the entrance test results were announced, the petitioner found that though they had obtained very good marks in the qualifying examination, they had not been able to secure admission to the college because the marks awarded to them at the viva voce examination were very low, and candidates who had much less marks at the qualifying examination had succeeded in obtaining very high marks at the viva voce examination and thereby managed to secure admission in preference to the petitioners. The petitioners, aggrieved by this mode of selection, filed the writ petitions challenging the validity of the admissions made to the college on various grounds. The respondents contended that the college is run by society which is not a corporation created by a statute but is a society registered under the Jammu and Kashmir Societies Registration Act, 1898, and it is therefore not an authority within the meaning of Article 12 of the Constitution, and no writ petition can be maintained against it, nor can any complaint be made that it has acted arbitrarily in the matter of granting admissions and violated the Equality Clause of the Constitution. Issue: whether the Regional Engineering College, Srinagar, sponsored by the Government of India, established, administered and managed by a society, registered under the Jammu and Kashmir Registration of Societies Act, 1898, was state under Article 12. Decision: a 5-judge bench consisting of Justice Y.V. Chandrachud, P.N. Bhagwati, V.R. Krishna Iyer, S. Murtaza Fazal Ali and A.D. Koshal observed as follows. I. It is obvious that the government may act through the instrumentality or agency of natural persons, or it may employ the instrumentality or agency of juridical persons to carry out its functions. In the early days, when the government had limited functions, it could operate effectively through natural persons constituting its civil service, and they were found adequate to discharge governmental functions which were of traditional vintage. But as the tasks of the government multiplied with the advent of the welfare state, it began to be increasingly felt that the framework of civil service was not sufficient to handle the new tasks, which were often specialized and highly technical in character and which called for flexibility of approach and quick decision-making. The inadequacy of the civil service to deal with these new problems came to be realized, and it became necessary to forge a new instrumentality or administrative device for handling these new problems. It was in these circumstances and with a view to supplying this administrative need, the corporation came into being as the third arm of the government, and over the years it has been increasingly utilized by the government for setting up and running public enterprises and carrying out other public functions. Today, with increasing assumption by the government of commercial ventures and economic projects, the corporation has become an effective legal contrivance in the hands of the government for carrying out its activities, for it is found that this legal facility of corporate instrument provides considerable flexibility and elasticity and facilitates proper and efficient management with professional skills and on business principles, and it is blissfully free from departmental rigidity, slow motion procedure and hierarchy of officers. The government in many of its commercial ventures and public enterprises is resorting to this resourceful legal contrivance of a corporation because it has many practical advantages and at the same time does not involve the slightest diminution in its ownership and control of the undertaking. In such cases, the true owner is the state, the real operator is the state, and the effective controllerate is the state, and accountability for its actions to the community and to Parliament is of the state. It is undoubtedly true that the corporation is a distinct juristic entity with a corporate structure of its own, and it carries on its functions on business principles with a certain amount of autonomy which is necessary as well as useful from the point of view of effective business management. But behind the formal ownership which is cast in the corporate mold, the reality is very much the deeply pervasive presence of the government. It is really the government which acts through the instrumentality or agency of the corporation, and the juristic veil of corporate personality worn for the purpose of convenience of management and administration cannot be allowed to obliterate the true nature of the reality behind which is the government. Now it is obvious that if a corporation is an instrumentality or agency of the government, it must be subject to the same limitations in the field of constitutional law as the government itself, though in the eye of the law it would be a distinct and independent legal entity. If the government acting through its officers is subject to certain constitutional limitations, it must follow a fortiori that the government acting through the instrumentality or agency of a corporation should equally be subject to the same limitations. If such a corporation were to be free from the basic obligation to obey the fundamental rights, it would lead to considerable erosion of the efficiency of the fundamental rights, for in that event the government would be enabled to override the fundamental rights by adopting the stratagem of carrying out its functions through the instrumentality or agency of a corporation, while retaining control over it. The fundamental rights would then be reduced to little more than an idle dream or a promise of unreality. It must be remembered that the fundamental rights are constitutional guarantees given to the people of India and are not merely paper hopes or fleeting promises, and so long as they find a place in the Constitution, they should not be allowed to be emasculated in their application by a narrow and constricted judicial interpretation. The courts should be anxious to enlarge the scope and width of the fundamental rights by bringing within their sweep every authority which is an instrumentality or agency of the government or through the corporate personality of which the government is acting, so as to subject the government in all its myriad activities, whether through natural persons or through corporate entities, to the basic obligation of the fundamental rights. The constitutional philosophy of a democratic socialist republic requires the government to undertake a multitude of socio-economic operations, and the government, having regard to the practical advantages of functioning through the legal device of a corporation, embarks on myriad commercial and economic activities by resorting to the instrumentality or agency of a corporation, but this contrivance of carrying on such activities through a corporation cannot exonerate the government from implicit obedience to the fundamental rights. To use the corporate methodology is not to liberate the government from its basic obligation to respect the fundamental rights and not to override them. The mantle of a corporation may be adopted in order to free the government from the inevitable constraints of red tapeism and slow motion, but by doing so, the government cannot be allowed to play truant with the basic human rights. Otherwise, it would be the easiest thing for the government to assign to a plurality of corporations almost every state business such as post and telegraph, TV and radio, railroad and telephones, in short every economic activity, and thereby cheat the people of India out of the fundamental rights guaranteed to them. That would be a mockery of the Constitution and nothing short of treachery and breach of faith with the people of India, because, though apparently the corporation will be carrying out these functions, it will in truth and reality be the government which will be controlling the corporation and carrying out these functions through the instrumentality or agency of the corporation. We cannot by a process of judicial construction allow the fundamental rights to be rendered futile and meaningless and thereby wipe out Chapter 3 from the Constitution. That would be contrary to the constitutional faith of the post-Maneka Gandhi era. It is the fundamental rights which, along with the directive principles, constitute the life force of the Constitution, and they must be quickened into effective action by meaningful and purposive interpretation. If a corporation is found to be a mere agency or surrogate of the government, in fact owned by the government, in truth controlled by the government, and in effect an incarnation of the government, the court must not allow the enforcement of fundamental rights to be frustrated by taking the view that it is not the government and therefore not subject to the constitutional limitations. We are clearly of the view that where a corporation is an instrumentality or agency of the government, it must be held to be an authority within the meaning of Article 12 and hence subject to the same basic obligation to obey the fundamental rights as the government. The court then addressed itself to the question as to how to determine whether a corporation is acting as an instrumentality or agency of the government, and dealing with that question, observed. A corporation may be created in one of two ways. It may be either established by statute or incorporated under law such as the Companies Act 1956 or the Societies Registration Act 1860. Where a corporation is wholly controlled by government not only in its policy making but also in carrying out the functions entrusted to it by the law establishing it or by the charter of its incorporation, there can be no doubt that it would be an instrumentality or agency of government. But ordinarily where a corporation is established by statute, it is autonomous in its working, subject only to a provision, oftentimes made, that it shall be bound by any directions that may be issued from time to time by government in respect of policy matters. So also a corporation incorporated under law is managed by a board of directors or committee of management in accordance with the provisions of the statute under which it is incorporated. When does such a corporation become an instrumentality or agency of government? The tests for determining as to when a corporation can be said to be an instrumentality or agency of government may now be called out from the judgment of Ramana Dyaram Shetty vs. International Airport Authority of India, Air 1979 South Carolina 1628, where it was held as follows. 1. One thing is clear that if the entire share capital of the corporation is held by government, it would go a long way towards indicating that the corporation is an instrumentality or agency of government. 2. Where the financial assistance of the state is so much as to meet almost entire expenditure of the corporation, it would afford some indication of the corporation being impregnated with governmental character. 3. It may also be a relevant factor whether the corporation enjoys monopoly status, which is the state-conferred or state-protected. 4. Existence of deep and pervasive state control may afford an indication that the corporation is a state agency or instrumentality. 5. If the functions of the corporation of public importance and closely related to governmental functions, it would be a relevant factor in classifying the corporation as an instrumentality or agency of government. 6. Specifically, if a department of government is transferred to a corporation, it would be a strong factor supportive of this inference of the corporation being an instrumentality or agency of government. If on a consideration of these relevant factors it is found that the corporation is an instrumentality or agency of government, it would, as pointed out in the International Airport Authority's case, be an authority and, therefore, state, within the meaning of the expression in Article 12. These tests are not conclusive or clinching, but they are merely indicative indicia which have to be used with care and caution, because while stressing the necessity of a wide meaning to be placed on the expression, other authorities, it must be realized that it should not be stretched so far as to bring in every autonomous body which has some nexus with the government within the sweep of the expression. A wide enlargement of the meaning must be tempered by a wise limitation. In this case, the society is empowered to conduct its affairs by rules framed by it with the approval of the government of Jammu and Kashmir and the central government. The money for running the college is provided by the state and central government. The state government, with the approval of the central government, is empowered to take action and to issue directions in matters relating to the working of the college. In case of mismanagement of the affairs, the state government is empowered with the prior approval of the central government to take over the administration and assets of the college. The general superintendence, direction and control of the affairs of the society and its income and property is vested in the Board of Governors. The board consists, inter alia, of the Chief Minister of the state as its chairman and nominees of the central and state governments, the All India Council of Technical Education, the Indian Institute of Technology in the region, the University Grants Commission, the faculty of the college, the Vice-Chancellor of the Jammu and Kashmir University and the Principal of the college as its ex officio member secretary. Admissions to the college are made by a committee constituted by the board on the basis of comparative merit to be determined by holding a written entrance test for 100 marks and a viva voce examination for 50 marks. In the light of the above enunciation and also applying the tests propounded in the International Airport Authority case, the court held that the society running the Regional Engineering College, Srinagar, was an instrumentality or agency of the government and other authority within the meaning of Article 12, therefore amenable to the writ jurisdiction of the High Court. Having examined the Memorandum of Association and the rules of the society, the court came to this conclusion, that the control of the state and central government was deep and pervasive and the society was a mere projection of the state and the central government, and on this basis it concluded that it was an instrumentality or agency of the state and central government and therefore was state under Article 12. In this case, the court took a step forward and observed that the concept of instrumentality or agency of the government was not limited to a corporation created by a statute only but may be equally applicable to a company or society also, which may be decided on the consideration of the relevant factors. Comment. In the case of Ajay Hasia, Supra, the court went one step further and held that a society registered under the Societies Registration Act could also be an instrument of state for the purpose of the term, other authorities, in Article 12. This part of the judgment of the Constitution Bench in Ajay Hasia, Supra, case was in direct conflict or was seen as being in direct conflict with the earlier Constitution Bench of this court in Subhajit Tiwari's case, Supra, which had held that a body registered under a statute and which was not performing important state function or which was not under the pervasive control of the state cannot be considered as an instrumentality of the state for the purpose of Article 12. The above conflict in the judgments of Subhajit Tiwari, Supra, and Ajay Hasia, Supra, of two coordinate benches was noticed by this court in the case of Pradeep Kumar Biswas and hence the said case was referred to a larger bench of 7 judges. Whether CSIR is a state? Pradeep Kumar Biswas vs. Indian Institute of Chemical Biology 2002, 5 SCC. Facts. In 1972, Subhajit Tiwari, a junior stenographer with the Council of Scientific and Industrial Research, CSIR, filed a writ petition under Article 32 of the Constitution claiming parity of remuneration with the stenographers who were newly recruited to the CSIR. His claim was based on Article 14 of the Constitution. A bench of 5 judges of Supreme Court denied him the benefit of that article because they held that the writ application was not maintainable against CSIR as it was not an authority within the meaning of Article 12 of the Constitution. The correctness of the said decision was raised before the Apex Court for reconsideration. The immediate cause for such reconsideration was dismissal of the writ application filed by the appellants, Pradeep Kumar Biswas and ANR. In the Calcutta High Court challenging the termination of their services by the respondent, Indian Institute of Chemical Biology, which is a unit of CSIR. The High Court relying on Subhajit Tiwari vs. Union of India, 1975, 1 SC. 485, held that the writ application was not maintainable against the respondent. Thereafter, the appellants filed an appeal to Supreme Court by way of special leave petition. A bench of 2 judges referred the matter to a larger constitution bench being of the view that the decision in Subhajit Tiwari required reconsideration, having regard to the pronouncement of this court in several subsequent decisions in respect of several other institutes of similar nature set up by the Union of India. Issue. Is the CSIR a state within the meaning of Article 12 of the Constitution, and if it is, should this court reverse a decision which has stood for over a quarter of a century? Decision. A 7-judge bench by a majority of 5-2 held that Council of Scientific and Industrial Research, CSIR, is an instrumentality of the state within the meaning of Article 12 of the Constitution. The court laid down the following parameters for gauging whether a particular body could treat it as state for the purpose of Article 12. 1. Principles laid down in Ajay Hansia are not a rigid set of principles so that if a body falls within any one of them it must ex hypothesi be considered to be a state within the meaning of Article 12. 2. The question in each case will have to be considered on the basis of facts available as to whether in the light of the cumulative facts as established, the body is financially, functionally, administratively dominated by or under the control of the government. 3. Such control must be particular to the body in question and must be pervasive. If this is found, then the body is a state within Article 12. On the other hand, when the control is merely regulatory whether under statute or otherwise, it would not serve to make the body of state. The court also considered whether the 5-judge decision in Subhajit Tewari vs. Union of India case was correctly decided. In that case, CSIR was held not to be state under Article 12. The court in this case, i.e. Pradeep Kumar Biswas case, again examined the constitution of the CSIR and the role of the government in the affairs of CSIR. The court noted that the government plays a vital role in the governing body of the CSIR, as Director General, who is ex officio Secretary of CSIR, is appointed by central government and members of council are nominated by the President, and he could also terminate their membership. The Prime Minister is ex officio President of the Council. In matter of finance, major contribution came from Government of India. In case of dissolution of CSIR, any property remaining after payment of all liabilities shall belong to the government. Accordingly, court overruled the Subhajit Tewari case and held though CSIR was formed under the Registration of Societies Act, 1860, but it is a state under Article 12 because government has overriding control over the organization. Whether ICRI is a state? G. Basir Reddy vs. International Crops Research Institute, Air 2003 SC 1764. Facts: the appellants were employees of International Crops Research Institute, ICRISAT. Their services were terminated. They filed writ petition before the High Court of Andhra Pradesh against ICRISAT and UOI. The writ petitions were dismissed. A second writ petition was also filed, but it was also dismissed. Both the division benches, while dismissing writ, held that ICRISAT was an international organization and was immune from being sued because of a notification issued in 1972 under the United Nations Privileges and Immunities Act, 1947, and that a writ under Article 226 could not be issued to ICRISAT, so this appeal lies to Apex Court. Issues: I. What or who is ICRISAT? E. Was the High Court right in holding that it was not amendable to the writ jurisdiction under Article 226? Decision: Court held ICRISAT is an international organization whose object is to help developing countries to alleviate rural poverty and hunger. The court further held as it was not set up by the government, so it is not controlled nor it is accountable to the government. So, ICRISAT is not a state or other authority as defined in Article 12 of the Constitution. The court further held that a writ under Article 226 can lie against a person if it is a statutory body or performs a public function or discharges a public or statutory duty. ICRISAT has not been set up by a statute nor its activities are statutorily controlled. The primary activity of ICRISAT is to conduct research and training programs in the sphere of agriculture purely on a voluntary basis. A service voluntarily undertaken cannot be said to be a public duty. Besides, ICRISAT has a role which extends beyond the territorial boundaries of India, and its activities are designed to benefit people from all over the world. While the Indian public may be beneficiary of the activities of the institute, it certainly cannot be said that the ICRISAT owes a duty to the Indian public to provide research and training facilities. So court held that High Court was right in dismissing the writ petition, and it was not maintainable against ICRISAT. Whether BCCI is state. Zee Telefilms vs. Union of India. 2005, 4 SCC 649. Facts. BCCI, a society registered under the Tamil Nadu Societies Registration Act, 1975, invited tender for grant of exclusive television rights for a period of 4 years. Several entertainment groups including the petitioners, Zee Telefilms, and the fifth respondent, ESPN Star Sports, known as S, gave their offers. Both the petitioner and the fifth respondent were found eligible therefore. Upon holding negotiations with the petitioner and the fifth respondent, the board decided to accept the offer of the former, and in furtherance whereof a sum of Rs. 92.50 crores equivalent to $20 million was deposited in the State Bank of Travancore. The fifth respondent in the meanwhile filed a writ petition before the Bombay High Court. The matter was taken up for hearing on day-to-day basis. On the 21st of September 2004, however, the board before commencing its argument stated that it purported to have cancelled the entire tender process on the premise that no concluded contract was reached between the parties, as no letter of intent had therefore been issued. The petitioner, however, raised a contention that such a concluded contract in fact had been arrived at. The fifth respondent, in view of the statements made by the counsel for the board, prayed for withdrawal of the writ petition, which was permitted. The order of the board dated the 21st of September 2004 terminating the contract is in question in this writ petition, contending that the action on the part of the board in terminating the contract is arbitrary and, thus, violative of Article 14 of the Constitution of India. Further, the petitioners have, inter alia, prayed for issuance of a writ in the nature of mandamus commanding upon the board to act in terms of the decision arrived on the 5th of September 2004. Issue: whether BCCI came within the meaning of state under Article 12, as it was a society registered under the Tamil Nadu Societies Registration Act, 1975 and recognized by the UOI, the Ministry of Youth Affairs and Sports. Decision: the court examined the evolution of Article 12 in the light of changing socio-economic circumstances. The court referred the observation of 7-judge bench of the court in Pradeep Kumar Biswas vs. Indian Institute of Chemical Biology, 2002, in respect of inconsistency between Subhajit Tewari vs. UOI, 1975, and Ajay Hasia vs. Khalid Mujib, 1981, both decisions of 5-judge benches. While the first case stated that a body created under a statute and not performing important state functions, or which was not under the pervasive control of the state, cannot be considered as an instrumentality of the state for the purpose of Article 12. The second case held that a society registered under the Societies Registration Act could also be an instrument of state for the purpose of the term other authorities in Article 12. The bench in Pradeep Kumar Biswas then went on to hold that the principles laid down in Ajay Hasia case are not rigid in nature, and what has to be examined in each case is whether the body is financially, functionally and administratively dominated by or under the control of the government. Furthermore, this control must be pervasive and not regulatory in nature. On the basis of the deep and pervasive state control test laid down in Pradeep Kumar Biswas, the majority held that the BCCI would not come within the definition of state under Article 12. The court observed that BCCI was not created by a statute, no part of share capital of BCCI was held by the government, the government provided hardly any financial aid to BCCI, and the monopoly status enjoyed by BCCI was not state-conferred or protected. Hence BCCI could not be held as state for the purpose of Article 12. On the other hand, basing its reasoning on the public function doctrine, the minority held that the BCCI would fall within the ambit of the definition of state under Article 12. The minority in this case opined that keeping in view the fact that the BCCI discharges an important public function and that its actions may impinge on the fundamental rights of the players, the actions of the body are subject to judicial review. Interestingly, the minority court in the same breath also opined that in times of privatization and liberalization wherein most of the governmental functions are being relegated to private bodies, the actions of such private bodies would also be amenable to the writ jurisdiction of the court. Whether the Uttar Pradesh Ganna Kishan Sansthan, a state of UPV. Radhe Shyam Ral. 2009. 3. Scale 754. Facts. Radhe Shyam Rai, respondent, was appointed as computer officer, data processing officer in Uttar Pradesh Ganna Kishan Sansthan, a society registered under the Societies Registration Act, 1860. The Sansthan was established by a government order. The function of Sansthan was imparting knowledge and training to the cane growers and connected persons so as to effect increase in the production of sugar in the state. For this, state had established training centers at Shahjahanpur, Muzaffarnagar and Gorakhpur. These training centers were being run by the Cane Development Department of the Government of Uttar Pradesh. Management of the said training centers was transferred to the Sansthan, the expenses of which were to be met from UP Sahakari Ganna Samiti Sangh and Sakkar Vishesh Nidhi. The Governing Council of the Sansthan in its meeting held on the 28th of April 1997 resolved to abolish the posts created and to cancel the appointments made, pursuant thereto. The service of the respondent was dispensed with by an order dated the 17th of May 1997. Feeling aggrieved by the said order, he filed a writ petition before the Lucknow bench of the High Court. Issue: whether the Uttar Pradesh Ganna Kishan Sansthan, a society registered under the Societies Registration Act, 1860 is a state within the meaning of Article 12 of the Constitution. Decision: court held that the main purpose and object for which the training institutes were established at different places in the state of Uttar Pradesh admittedly was to provide scientific ways of sugarcane cultivation and management so as to improve the production of cane with a view to achieve better production of sugar. Such a function indisputably is a state function. The state established the Sansthan so as to take over its own functions. It even transferred the entire management relating to imparting of training in various institutes in its favor. All the assets held by it for the aforementioned purpose, including the infrastructural facilities, stood transferred in favor of the Sansthan. It was created under a government charter contained in the government order dated the 4th of August 1975 issued in the name of the government of Uttar Pradesh. Court further held that 80 to 90% of the expenditure of Sansthan was met out of the funds made available to it by the government. The majority of the office bearers of the Governing Council were holders of various offices of the government. It had, thus, a dominance of the holders of the office in the government of Uttar Pradesh. The minister in charge of cane department being its ex officio chairman of the Governing Council. He is the chief executive authority. The director and accounts officer are also the government servants, and the Sansthan is not free to appoint anybody on those posts who is not a government servant. The functions of the Sansthan are public functions. From the materials placed before the court, there cannot be any doubt whatsoever that the state exercises a deep and pervasive control over the affairs of the Sansthan. Therefore, the Sansthan is a state within the meaning of Article 12 of the Constitution. In Jatya Pal Singh vs. Union of India 2013-6 452. The engineers and technical staff were working in the Department of Overseas Communications, which was later converted into VSNL. Between 1992 and 2000, Government of India divested a portion of its shareholding in VSNL and it became a Tata company and the name changed to Tata Communications Limited. As per the shareholding and share purchase agreements, Government of India mandated Tata to ensure that none of the employees should be retrenched for 1 year. However, services of 20 managerial employees were terminated in 2007 after paying them 3 months' salary in lieu of notice. 10 petitions were filed by the employees in the Delhi High Court and 2 in Bombay High Court challenging termination orders. Their petitions were dismissed as the company was no longer a state enterprise. It was appealed before Supreme Court. The Supreme Court also dismissed the appeal and held that Tata Communications, the successor of VSNL, was providing commercial service for profit considerations and it is not performing public functions or a mandatory public duty, thus the terminated employees cannot move high courts for redressal of their grievances. Merely because Tata Communication Limited is performing the functions which were initially performed by Overseas Communications would not be sufficient to hold that it is performing a public function, the Apex Court said, adding that a perusal of the documents would show that VSNL had merely promised not to retrench any employee who had come from Overseas Communications for 2 years. But such a condition would not clothe the same with the characteristic of a public duty which the employer was bound to perform. The Supreme Court asked the employees to approach ordinary fora like the industrial courts to enforce their rights. Leading case: BCCI v. Cricket Association of Bihar 2015-3 SC 251. BCCI performs public function and is amenable to writ jurisdiction of the High Court under Article 226 of the Constitution. Facts: the BCCI in 2007 decided to launch the Indian Premier League (IPL), and in a subsequent meeting held on the 27th of September 2008, decided to appoint Mr. N. Srinivasan as Secretary of BCCI, and in the same meeting BCCI amended its Regulation 6.2.4 in order to exclude the IPL and Champions League T20 from its purview. In April 2013, Delhi police received information in relation to spot fixing in IPL and charges were levelled against Raj Kundra, the owner of Rajasthan Royals, and Gurunath Mayappan, the son-in-law of N. Srinivasan, who was also the owner of the IPL team Chennai Super Kings. BCCI constituted a committee headed by Sri Sanjay Jagdale and 2 retired judges of Madras High Court, and after his resignation the probe committee consisted of the 2 retired judges. After this, a PIL was filed by Cricket Association of Bihar before the Bombay High Court seeking the constitution of committee to be declared ultra vires of the constitution and sought the appointment of retired Supreme Court judges in the panel. They also prayed for termination of contract of IPL franchisee Chennai Super Kings and Rajasthan Royals with BCCI and initiation of disciplinary proceedings against N. Srinivasan. The court in an order dated 30th of July 2013 declared constitution of probe commission in contravention to provisions 2.2 and 6 of IPL operational rules. The High Court, however, denied relief in the form of constitution of commission consisting of retired judges. Thereafter, an appeal was filed before the Supreme Court by Cricket Association of Bihar. Issue: whether BCCI is state under Article 12 of the Constitution, and if not, whether it is amenable to the writ jurisdiction of the High Court under Article 226 of the Constitution of India. Decision: a 2-judge bench consisting of Justice T.S. Thakur and Justice F.M. Ibrahim Khalifullah referred the case of C Telefilms Limited and ANR v. Union of India and Oz. 2005, 4 SCC 649, where this court by a majority of 3:2 has held that BCCI was not state within the meaning of Article 12. This court held that the board was not created by any statute, nor was a part of the share capital held by the government. There was practically no financial assistance given to the board by the government, and even when the board did enjoy a monopoly status in the field of cricket, such status was not state-conferred or state-protected. So also there is no deep and pervasive state control. The control, if any, is only regulatory in nature as applicable to other similar bodies. The control is not specifically exercised under any special statute applicable to the board. All functions of the board are not public functions, nor are they closely related to governmental functions. The board is not created by transfer of a government-owned corporation and was an autonomous body. Relying upon the tests laid down in Pradeep Kumar Biswas's case, this court held that the board was not financially, functionally or administratively dominated by or under the control of the government so as to bring it within the expression state, appearing in Article 12 of Constitution. After referring the above case, court in the present case held that though the Board of Cricket Control of India, BCCI, is not state within the meaning of Article 12, but it is amenable to the writ jurisdiction of the High Court under Article 226 of the Constitution even when it is not a state within the meaning of Article 12 as it discharges public functions. The natural corollary flowing from this finding is that all actions which BCCI takes while discharging such public functions are open to scrutiny by the courts in exercise of their powers under Article 226 of the Constitution. It also implies that such actions shall when under scrutiny be judged by the standards and on principles that govern similar actions when taken by the state or its instrumentalities. The approach which a court exercising powers of judicial review of administrative action adopts will remain the same irrespective of whether the action under review is taken by the state or its instrumentality or by any non-statutory non-government organization like the BCCI in the case at hand. The rationale underlying this view lies in the nature of duties and functions which the BCCI performs. The Board of Cricket Control of India, BCCI, has a complete control over the game of cricket in this country. It regulates and controls the game to the exclusion of all others. It formulates rules, regulations, norms and standards covering all aspects of the game. All these activities are undertaken with the tacit concurrence of the state government and the Government of India, who are not only fully aware but supportive of the activities of the board. The state has not chosen to bring any law or taken any other step that would either deprive or dilute the board's monopoly in the field of cricket. On the contrary, the Government of India have allowed the board to select the national team, which is then recognized by all concerned and applauded by the entire nation, including at times by the highest of the dignitaries when they win tournaments and bring laurels home. Any organization or entity that has such pervasive control over the game and its affairs and such powers as can make dreams end up in smoke or come true cannot be said to be undertaking any private activity. The functions of the board are clearly public functions, which, till such time the state intervenes to take over the same, remain in the nature of public functions, no matter discharged by a society registered under the Registration of Societies Act. Suffice it to say that if the government not only allows an autonomous, private body to discharge functions which it could in law take over or regulate, but even lends its assistance to such a non-government body to undertake such functions, which by their very nature are public functions, it cannot be said that the functions are not public functions or that the entity discharging the same is not answerable on the standards generally applicable to judicial review of state action. Comment. The legal status of BCCI merely that of a society which is registered under an act, but with the changing scenarios various approach has been adopted to clear the position of BCCI with regard to its status under Article 12 of the Constitution of India. From Mohinder Amarnath's case till cricket's case, various positions have been taken, but through the landmark judgment of Zee Telefilms, one thing was made clear, that the board is not stayed under Article 12 because it does not fall into the category specified by a 7-judge bench in Pradeep Kumar Biswa's case. But the question again came up whether or not BCCI performs public function. Through this judgment, it was made clear that board performs public functions because of the indefinite and enormous powers it possesses in the domain of cricket, and not only this, but it also has tacit consent of the government, since all the activities it performs, it gets support from Government of India. Leading case: Dr. Janet J. Paul vs. SRM University. Air 2016, South Carolina 73. Is imparting of education by private educational institutions a public function? Facts: the services of Dr. Janet J. Paul, appellant, who was a faculty member in SRM University, respondent, a deemed university under Section 3 of the UGC Act, 1956, was terminated by the university for the alleged failure to take classes of the students of B.Sc. third-year degree course and M.Sc. first-year degree course. Though the appellant submitted her replies denying the allegations and claiming that she took classes for both the courses, the same was not accepted by the university, and she was served a notice mentioning therein that the same shall be treated as 1 month's notice and she would be relieved from the services after that. After this, the appellant filed a writ petition before the single judge of the Madras High Court. The single judge of the High Court quashed the termination notice and directed the respondents to reinstate the appellant into service. Against the said order of the single judge, the respondent university filed appeal before a division bench, the High Court, where the division bench of the High Court held that the writ petition filed by the appellant against respondent was not maintainable because the respondent is neither a state nor an authority within the meaning of Article 12 of the Constitution of India, and hence it cannot be subjected to writ jurisdiction of the High Court under Article 226 of the Constitution. Aggrieved by the said judgment, the appellant preferred appeal by way of special leave to the Supreme Court. Contentions of the parties: The amicus curiae appointed by the Supreme Court on behalf of the petitioner submitted that while deciding the question as to whether the writ lies under Article 226 of the Constitution of India against any person, juristic body, organization, etc., the test, in the first instance, is to examine the object and purpose for which such body, authority, organization is formed, as also the activity which it undertakes to fulfill the said object, purpose. The approach of the court while deciding this question is to assess as to whether the concerned body is formed for discharging any public function or public duty, and if so, whether it is actually engaged in any public function or and performing any such duty. If the case complies with this twin test, such person, organization, as the case may be, would be subjected to the writ jurisdiction of the High Court under Article 226 of the Constitution of India. It was further contended that the expression, any person or authority, used in Article 226 of the Constitution of India are not confined only to statutory authorities and instrumentalities of the state, but may in appropriate case include any other person or body performing public function, duty. It was further pointed out that the SRM University is a juristic body engaged in imparting education in higher studies and is conferred with the status of deemed university by the central government under Section 3 of the University Grant Commission Act, 1956, and imparting education to students at large is a public function, and, therefore, if any authority is found to have been engaged in the activity of imparting education to the students at large, then irrespective of the status of any such authority, it should be made amenable to writ jurisdiction of the High Court under Article 226 of the Constitution of India. One of the submissions made on behalf of the SRM University was that if this court holds that the SRM University is amenable to writ jurisdiction, then apart from employees, even those who are otherwise dealing with the SRM University would start invoking writ jurisdiction, which would open the floodgate of litigation in courts. Issue: whether it lies under Article 226 of the Constitution of India against any person, juristic body, organization, authority etc. Decision: the Supreme Court held that the Division Bench of the High Court erred in holding that the SRM University is not subject to writ jurisdiction of the High Court under Article 226 of the Constitution of India. The Supreme Court observed that when a private body exercises public functions, even if it is not a state, the aggrieved person has a remedy not only under the ordinary law but also under the Constitution, by way of a writ petition under Article 226. The Supreme Court gave the following reasons to reach such conclusion. Firstly, respondent, SRM University, is engaged in imparting education in higher studies to students at large. Secondly, it is discharging public function by way of imparting education. Thirdly, it is notified as a deemed university by the central government under Section 3 of the UGC Act. Fourthly, being a deemed university, all the provisions of the UGC Act are made applicable to respondent, which inter alia provides for effective discharge of the public functions, namely education for the benefit of public. Fifthly, once respondent is declared as deemed university, whose all functions and activities are governed by the UGC Act, unlike other universities, then it is an authority within the meaning of Article 12 of the Constitution. Lastly, once it is held to be an authority, as provided in Article 12, then as a necessary consequence, it becomes amenable to writ jurisdiction of High Court under Article 226 of the Constitution. Comment: the Supreme Court judgment has a far-reaching implication for educational institutions, as it not only provides an additional remedy against the deemed universities, and by implication other educational institutions performing public function and public duty, but a substantial one, as the High Courts have wide powers under Article 226 of the Constitution of India, which can now be used frequently by the litigants against such institutions to secure their fundamental rights. Therefore, while on one hand, the judgment is being welcomed by students and public at large, the deemed universities and other institutions for education are not too pleased. Whether judiciary is state under Article 12? Article 12 defines state for the purposes of Part 3 and Part 4 of the Constitution. It does not expressly mention the judiciary. However, through judicial interpretation it is possible to bring it under other authorities mentioned in the Article 12. A reading of the Constituent Assembly debates regarding Article 12 shows that there was reasonable apprehension regarding the wide scope afforded to the term authority as used in draft Article 7. It was felt that a magistrate or even a petty official in authority could rightly claim under this article to have the authority to abridge a citizen's fundamental rights. The apprehension that those binding power could violate the rights guaranteed by Part 3 was evident even then. Dr. Ambedkar proceeded to define authority as every authority which has the power to make laws or the power to have discretion vested in it. Emphasis added, although it is a point of contention whether the term discretion here refers to administrative or judicial discretion, it is possible, reading it together with reference to magistrates, that the constitution makers meant to bring the judiciary under Article 12. This is further supported by the fact that the definition is inclusive and not exhaustive. In Ratilal vs. State of Bombay, A 1953 Bohm. 242. Court held in the definition of the state in Article 12, judiciary is not specifically mentioned. Therefore, the judgments of courts cannot be challenged on the ground that they contravene fundamental rights. In Ujjam Bai vs. Union of India, A 1962 SC 1621, Court held that a writ of certiorari could lie to bodies which are under an obligation to act judicially or quasi-judicially. Since such a writ lies, it follows that there are some fundamental rights which can be violated by a judge acting judicially in a court. Since the binding power of any judgment of the Supreme Court is based on the fact that it is backed by state which has the power and necessary resources to enforce, it would only be logical that the judiciary itself be considered part of the state. An often quoted example is that of a judge who denies the entry of an untouchable into his courtroom. She would be guilty of violating Article 17. If a judge compels someone to answer incriminating questions, he is guilty of violating Article 23. A trial under such conditions should be stopped and a petition filed in the superior courts under their writ jurisdiction. In Prem Chand Garg vs. Excise Commissioner, Air 1963 South Carolina 996, it was held that when the judiciary acts in the judicial capacity, it is not included within the meaning of the term, other authorities, and therefore it is not state under Article 12, but when it acts in administrative capacity, it is included within the meaning of the term, other authorities, and therefore it is state. In Paramatma Sharan vs. Chief Justice, Air 1964 Raj. 13. The court held that the judgments of the court cannot be challenged on the ground that they violate the fundamental rights whether or not the judgment of the court suffer from any infirmity. It can be decided only in appeal. However, if the judiciary acts in administrative capacity or exercises administrative function or make rules and its actions or rules contravene fundamental rights, they may be challenged in the court. Thus, if the rules made by the Supreme Court or High Court contravene the fundamental rights, they may be challenged in the court. When the Chief Justice of the High Court or Supreme Court appoints officer of the court in the exercise of his power of appointment and the appointments made by him contravene any fundamental right, they may be challenged in court because when the Chief Justice of the Supreme Court or High Court makes an appointment in the exercise of the power of appointment, he acts in administrative capacity and therefore, he is included within the meaning of the term, state, under Article 12. In Naresh Sridhar Mirajkar vs. State of Maharashtra, AIR 1967 South Carolina 1, petitioner, a journalist, argued that the trial judge's order to the press, restricting them from publishing the testimony of the defense witness in a particular case was violative of his fundamental right. It was urged before the judge that the fundamental principle in the administration of justice was that it must be open to the public and that exceptions to such public administration of justice were rare. No witness could claim protection from publicity on the ground that if the evidence is published, it might adversely affect his business. The arguments were summarily rejected. The High Court dismissed the petition on the ground that a judicial order was not amenable to writ jurisdiction. The Supreme Court, which admitted the petition under Article 32 for violation by the trial judge's judicial order of fundamental rights under Articles 19(1)(a) and 19(1)(g) of the Constitution, brought up the following issues. Firstly, whether judicial order suppressing evidence of a witness on the grounds that his business would suffer breaches the fundamental right to freedom of speech and expression, entitling the petitioner to invoke Article 32, and secondly, whether the Supreme Court could issue a writ to the High Court in this instance. The majority held that suppression of evidence in question was necessary to serve the cause of justice, that is, to ensure fair trial. It was also opined that the impugned order would not violate Article 19(1)(a), since the power to withhold publication or to hold an in-camera trial were both protected by Article 19(2). Third-party rights may be affected by the exercise of such powers, however, they must be of secondary importance to the effective administration of justice. Moreover, since the freedom of speech was affected only incidentally and indirectly, there was no violation of fundamental rights. In A.R. Entule vs. R.S. Nayak, Air 1998 South Carolina 1531, a Constitution bench of the Supreme Court, by its order had withdrawn the prosecution of Mr. Entule from the special judge, who had been trying the case, and had directed the Chief Justice of Bombay High Court to nominate a High Court judge, before whom the trial could proceed. Pursuant to this direction, a High Court judge was nominated to hold the trial. Mr. Entule questioned this direction by a writ petition under Article 32 of the Constitution, which was rejected by a two-judge bench. Subsequently, when the trial in the High Court